States is not permanent, it's a temporary green card. The applicant, aka you, the beneficiary, must wait a certain amount of time before you can apply to remove these conditions. When that time is up, you must apply for a permanent green card or risk being deported. Once you go through another application process and are approved, you receive a permanent green card. Tonight, I'm going to talk about what a conditional green card is. I'm going to explain what you must do to have the conditions removed and when you must do that. Sometimes divorce happens. I'm going to explain how that might impact your chance of getting a permanent green card and options you have if it takes place before you receive your permanent status.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
What to do if you have separated from your spouse? How do you remove the conditions on your green card? So the first scenario, we're really talking about a joint petition where husband and wife are together, and those are mistakes that you can make even if you guys are still together, even if it's a legitimate marriage. If you don't document it right, you can have a problem. Now, what do you do if your spouse left you? What do you do? How do you do a joint petition if your spouse won't join in the petition? Now you got a problem. So generally Form I-751 is a joint petition by you and your spouse. However, there are circumstances that you can file on your own. The first is a good faith waiver. This is, now in order to qualify for this, you have to already be divorced. Being separated isn't enough. You need to include the divorce decree, not just the divorce complaint. And you must also show that your marriage was good faith by providing the evidence above. So basically, hey, your marriage was real, but it didn't work out. Look, the fact is 50% of marriages end in divorce. It's typically helpful to have an affidavit from your former spouse explaining you guys loved each other, but unfortunately it didn't work out. Now it could be just as basic as that, or she can go into a lot more detail. It's all right. Every case is slightly different. So first is the good faith waiver. Second is you're a widower. Unfortunately, your spouse died. You need to include a death certificate and again prove that your marriage entered in good faith, but you don't need to show much else other than married in good faith and all that documentation, the examples I gave before, and that your spouse is now deceased. Now, you don't need, if your spouse dies, you don't need to wait 2 years to file to move the conditions off your green card. The moment your spouse passes away, you can immediately file, even if you've only had your green card for a day. Obviously, that's not going to happen, but you get my point. Third is you're a battered spouse. So here is where you suffered extreme cruelty. You or your child filed extreme cruelty, and you need to prove that. For example, police reports, therapist, medical records, photos of abuse, restraining orders. You still need to show that you entered the marriage in good faith, as discussed above, and you'd still be together, but for the way that you or your child was horribly treated by your spouse, who has to be a citizen or a green card holder. If they're not a spouse or green card holder, guess what? You don't have the conditional green card because they can't give you what they don't have. Don't let the 2 years pass by without filing. No matter what happens, don't let the time pass. It's a real problem because, again, immigration will put you into removal proceedings. So thank you for joining us. I'm Andrés Mejer. Until next time.